This is Bloomberg Law with June Grasso from Bloomberg Radio.
Look, I just want to keep serving. I'm at 19 and a half years. I have 60 combat missions in Iraq and Afghanistan. I'm a certified test pilot, flown over 21 airframes and 1,700 flight hours in aircraft like the F-18 that you saw in Top Gun 2. I just want to keep doing my job.
Emily Schilling is a decorated Navy commander and combat pilot. She is also transgender and is challenging President Trump's ban on transgender people serving in the military. A federal judge had blocked the ban, finding there was no evidence that transgender troops posed a threat to military readiness. But this week, the conservative justices on the Supreme Court, over the dissents of the 3 liberal justices, paused that order to allow the Trump administration to start discharging thousands of transgender service members, including experienced officers who've served openly for years. Defense Secretary Pete Hegseth said the military is leaving wokeness and weakness behind.
No more pronouns, no more climate change obsession, no more emergency vaccine mandates, no more dudes in dresses. We're done with that.
My guest is constitutional law expert David Super, a professor at Georgetown Law. This is a 1-paragraph order, so we have no idea what their reasoning was. We just know that the 3 liberal justices dissented. What's your take on this decision?
I think it's disappointing because the plaintiffs made a compelling case. This looks like a classic equal protection claim. The executive order, as plaintiffs say, is dripping with contempt for transgender people. So this is bigotry, not military preparedness, and I would have hoped the court would have treated it accordingly. But that doesn't mean that they've resolved it on the merits.
A federal judge in Washington state had blocked the ban. Actually, 2 federal judges have blocked it. Judge Benjamin Settle said it's not an especially close question. Will you tell us about the claims of the transgender troops in this case?
Their, I think, most central claim is that they're being denied equal protection of the law. The Supreme Court has long held that the Fifth Amendment's requirement of due process implicates equal protection of the law, and that the federal government may not deny people equal protection, particularly if it is discriminating on the basis of a historically sensitive category. The soldiers are alleging that they're being discriminated against both because of sex and because of their transgender status, and that the government has nowhere near enough adequate justification for doing this.
In a case like this, shouldn't they have allowed the status quo to remain in place? Now the Trump administration is going to be able to discharge thousands of troops.
That certainly would be the usual practice, and the practice the court has insisted on in many cases involving the Biden administration, where they prohibited the change from taking place until it was properly litigated. This opinion from the district court in Washington is quite long, quite detailed, quite careful. You can agree with it or not, but it is certainly not a casual opinion, and one would expect that it would stand and preserve the status quo unless there was a compelling reason otherwise. It's disappointing that the Supreme Court was unable or unwilling to state any compelling reason for this change in the status quo.
At the Supreme Court, what the Trump administration argued was that judges are required to show substantial deference to the Defense Department's judgment on military issues. Do you think that deference is the main reason why the Supreme Court decided to lift the injunction?
I suspect it is. The president has been asking for deference on many military and foreign affairs matters. The court denied him that deference on his efforts to use the Alien Enemies Act, and my guess is that the court is trying to balance the scales in that regard.
And as far as whether irreparable injury will be suffered, the order requires the transgender troops to voluntarily separate from the military or face, quote, involuntary separation, which is a stain on their records that could deny them veterans benefits. So That scenario seems like irreparable injury.
I mean, in principle, the administration could be ordered to restore their prior status if it ultimately loses this litigation. But the whole point of irreparable injury is that litigants are forced to suffer circumstances that can't be fully corrected. And in the best case scenario, having one's military service interrupted, having to gamble one's VA benefits away, all of that is classic irreparable injury.
In Trump's first term, the Supreme Court allowed an earlier transgender military ban to take effect, but that first ban exempted current troops. So it was more like a ban on enlistment. This goes further because it's going to allow them to discharge people who are currently serving.
Yes, this is very different than what we saw before. And that's, I think, the core of what the lower court found is that there simply was no evidence to support this. If the government had an important reason for an action, then deference would be owed, and the lower court firmly upheld that. But it found that this was not a military judgment, but a political judgment by the president that the Secretary of Defense carried out without gathering any evidence that these people are not able to serve their country effectively. And what's striking about the plaintiffs in this case is that we know a lot about them. They've been serving. They've been performing. And if they weren't, they could certainly be thrown out on an individual basis. But throwing them out on the basis of prejudice when we have ample evidence that they're effective soldiers and service people is disturbing, and it's ignorant.
I'm surprised that one of the three liberals didn't write a dissent. Are you?
Not necessarily. If the liberals write a dissent, then either the majority or some justice in the majority write an opinion defending what was done, and that would tend to lock in positions. This is such a disturbing and difficult to justify action that I think the liberals may have decided that it's best that no one put pen to paper any more than necessary right now, and hope that this can be reversed when it's heard on the merits.
So this was about the order from the judge in Washington State. A judge in Washington, D.C. has also blocked the policy, and the Court of Appeals for the D.C. Circuit put that on hold temporarily while it heard oral arguments. I mean, how does that case work out when you have the Supreme Court lifting the injunction of the Washington State judge?
That's precisely why the absence of opinions is so significant and so telling here. Panels in the Ninth Circuit and the D.C. Circuit will write opinions about this, and it will almost certainly come back to the Supreme Court on the merits. So it's really wide open. There are many grounds for denying a stay or granting a stay, and precisely because the court didn't write an opinion, we don't know which of those it is. It could be something as technical as concerns about the standing of plaintiffs or concerned about whether they made a proper demonstration of irreparable injury. So there's nothing about this action that prejudges the merits. They have lifted injunctions in other cases saying we don't think the plaintiffs are likely to prevail on the merits. They didn't say that here.
So if this could come back to the court and the justices could have a different opinion?
Well, it would come back to the court in a different form, and they could very well be inclined on the merits to find for the plaintiffs, even if they didn't think an injunction pending litigation was appropriate.
I also want to ask you about a controversial comment by President Trump on Meet the Press last Sunday.
Don't you need to uphold the Constitution of the United States as president?
I don't know. I have to respond by saying again, I have brilliant lawyers that work for me, and they are going to obviously follow what the Supreme Court said.
I mean, in the past, he has talked about his Article 2 powers under the Constitution.
Well, the Constitution has many things in it. It has Article 2, which I'm sure he feels the need to uphold. Then those pesky Article I and Article III and Bill of Rights. Perhaps he's less enthusiastic about those. I think that the people that need to hear his remarks are the Supreme Court. And the Supreme Court has, in a variety of ways, all spring been kicking the can down the road and hoping the administration will come around to acting lawfully. Arguably, the action we were discussing concerning the transgender ban in the military is another example of the court kicking things down the road. But a president who has harshly criticized judges, called some judges that he appointed communists, and has expressed great indifference about whether to comply with Supreme Court decrees and has not complied with several Supreme Court and lower court decrees, is not going to voluntarily change his tune. And the Supreme Court is going to have to decide whether they are going to insist upon compliance with the law.
They'll certainly have opportunities to do that, considering the record number of emergency applications from the Trump administration to the Supreme Court. Thanks for joining me, David. That's Professor David Super of Georgetown Law. I'm June Grasso, and you're listening to Bloomberg.
We, the jury, find the defendant Benjamin David Elliott guilty of murder as charged in the indictment.
We, the jury, being duly impounded and sworn, do find the defendant Adam Coy guilty of murder as he stands charged in count 1 of the indictment, signed this 4th day of November 2024.
The jury unanimously finds the murder willful, deliberate, and premeditated. The jury unanimously finds the murder was committed by means of lying in wait.
No matter how it's phrased, a jury verdict is considered sacrosanct. A unanimous decision reached by jurors beyond a reasonable doubt after deliberating on the evidence presented in a criminal trial. But in a completely unorthodox move, the new U.S. attorney in Los Angeles is interfering with a jury's verdict of guilt. After a 3-day trial, a jury convicted former L.A. County Sheriff's Deputy Trevor Kirk of a felony for using excessive force when he assaulted a black woman outside a supermarket 2 years ago. He's facing a 10-year prison sentence for that felony conviction. But now, in an extraordinary, almost unheard-of move, the U.S. Attorney Bill Aselyi is trying to override the jury's verdict by giving Kirk a plea deal, allowing him to plead to a misdemeanor and asking the trial judge to strike the jury's finding. 3 L.A. prosecutors have resigned in protest. My guest is former federal prosecutor Jimmy Gurule, a professor at Notre Dame Law School. So, Jimmy, this former sheriff's deputy is supposed to be sentenced this month on a felony conviction, facing 10 years in prison, and then suddenly the new U.S. attorney comes in and gives him a deal to plead to a misdemeanor and asks the judge to strike the jury's finding that Kirk injured the victim, which is what made it a felony.
Well, it's an extraordinary action, and it doesn't appear to be justified based on the facts or the law. And when I say that, what I mean is that if the claim was that he had not received a fair trial, well, that's the purpose of a direct appeal. The defendant would appeal the conviction and highlight the errors or alleged errors that were conducted during the jury trial. But there doesn't appear to be any allegations by the state or the defendant that his trial was not fair, did not comport with due process of law. Alternatively, if the claim is, we have newly discovered evidence that proves his innocence, well, there's a whole set of post-conviction procedures that deal with that process to petition the court through a petition for post-conviction relief to vacate the conviction. And there's no claims or allegations made to that effect that, he's actually innocent, and we just learned after the conviction of this new evidence that proves his innocence. And so then the question is, well, what is the justification? What's changed? What's the justification for this extraordinary action? Basically to override the verdict of the jury. And it appears that it's simply that there's been a change of administration. There's a new U.S. attorney, and he was prosecuted under the previous Biden administration. At least the initial indictment was brought at that time, and the charges were filed. And the new sheriff in town wants to undo what the jury did, which suggests to me that the motivation or justification is purely political.
Yeah, and there is no explanation for why they're giving Kirk this plea deal. And the trial judge in the case denied a motion by the defense for acquittal last month. and said Kirk acted aggressively toward the woman from the outset, and then the footage of the incident was sufficient evidence for a jury to find that he had used objectively unreasonable force.
Yeah, so as a matter of fact, the court is finding that there was sufficient evidence presented at trial to justify the conviction. And as a result, the defendant received the full panoply of due process protections. I mean, he was represented by counsel. Prosecution had to prove his guilt beyond a reasonable doubt. The jury had to find him guilty unanimously. And so there, again, does not appear to be any factual basis, justification, or legal justification for overturning the conviction. And what it suggests to me is that this is another example of the Trump administration kind of ignoring or evading the rule of law. In the case of undocumented immigrants, the claim is, well, they're not entitled to due process. In this particular case, with respect to Deputy Trevor Kirk, he received full due process, but the Trump administration didn't like the result. And because they didn't like the result, then they're seeking to somehow vacate the jury conviction, which I think undermines the rule of law and undermines the public's confidence in the criminal justice system and the validity of jury convictions.
Also, the 4 federal prosecutors who were working on the case refused to sign the plea agreement and withdrew from the case. And then 3 of them, including the chief of the Public Corruption and Civil Rights section, resigned from the office.
Yeah, they stepped down, which is an expression of their disagreement with this result and their perception, understanding that this was just an unfair, unjustified action by their supervisor. And again, is not justified by any, legal principle and any legal precedent, any legal authority. And, there's kind of a parallel here. With respect to plea bargains, for example, if a defendant enters into a plea bargain, he may withdraw the plea bargain after the fact, but only based upon a finding by the court that withdrawing the guilty plea would be in the interest of justice. And so what's the standard here? If the judge is ultimately to decide whether or not a valid jury verdict should be overridden for political considerations, that doesn't strike me as advancing the interests of justice. In fact, it's just the opposite. It's ignoring justice. Justice was done in this case. In the absence, again, of any claims of wrongdoing, unfair trial, ineffective assistance of counsel, any of those types of legal arguments, this was a valid conviction. And it shouldn't be ignored and disregarded by the Department of Justice. Apparently, the only reason being that they just didn't like the end result.
Yeah, well, there was sort of a social media campaign of support for Kirk, and a spokesperson for the L.A. Sheriff's Professional Association wrote a letter to Trump urging him to intervene before the case went to trial.
That's the political reason. That was a political influence that apparently caused the U.S. attorney to seek to override the jury's conviction, and that's not a legitimate basis. Conviction should be based on the facts and the evidence, not on political issues, political influence, political affiliation with one party or another. That's not democracy in the United States. That's not the way democracy works in this country. This type of outcome is going to serve to undermine the public's confidence in the rule of law and the criminal justice system. And they're going to say, well, how come this guy got such favorable treatment and result? What about the other guy? What about somebody who wasn't a political favorite? What about someone who wasn't a law enforcement officer? What about someone who's an ordinary citizen? Would the ordinary citizen receive this type of outcome, a guilty verdict being overturned for political reasons? Highly unlikely.
And why should I waste days, weeks, or even months sometimes serving on a jury when you're going to throw out my verdict?
Exactly. It has so many negative, corrupting implications. I'm really hopeful that the judge rejects this motion to withdraw the guilty verdict and permit Kirk to plead guilty to a misdemeanor. He's convicted of a felony, and now they want him to plead to a misdemeanor, and then they're going to give him probation. It's just shocking. A shocking action by the Department of Justice.
The final decision is up to the trial judge, and he's questioning whether he even has the authority to grant the government's motion to strike part of the jury's verdict. He's asking both sides to file briefs on it.
It's such an extraordinary action. I really strain to come up with the legal authority. What's the legal authority for the judge, the trial judge, to vacate a valid jury conviction? And I'm not aware of any. I'm not aware of any statute. I'm not aware of any case precedent that would afford the trial judge that authority. So that's clearly an issue. The problem here is who's going to appeal? I mean, if the judge does this and vacates the jury conviction, who's going to appeal it? Because the parties are in agreement. The defense certainly would like this outcome, and the prosecutor's office, U.S. Attorney's Office, is proposing this result. And so there would be no way to judicially review the trial court's decision. And so I think it would be final.
Also, if he's allowed to plead down to a misdemeanor, that means he could continue to work as a law enforcement officer and he could retain his right to own a firearm?
Well, I think that's part of it. I think that's part of the justification, at least from the U.S. Attorney's Office. We don't want him to have the stigma of a felon and all of the implications that are associated with being a convicted felon, which again would prohibit him from possessing a firearm. So that's a federal crime for a felon to possess a firearm. And so he couldn't work in any capacity that would require him to carry a firearm. But, that's what happens to defendants every day. Thousands of defendants are convicted of felonies, and that's one of the implications. They're prohibited from possessing a firearm. So what's so unique about this guy? Why does he get a pass? Why should he be permitted to avoid that consequence of a felony conviction? I can think of none other than political.
It's reminiscent of all the federal prosecutors who resigned when the Manhattan U.S. Attorney's Office was told to drop the charges against New York City Mayor Eric Adams so that he could help the Trump administration in its immigration arrests.
Right. I think it's another instance where the line prosecutors that are doing the heavy lifting in these cases are just outraged by the political influence that the Trump administration is having on the performance of their duties and obligations. They know, and I know, having served as a former federal prosecutor, that these convictions should be based solely on the facts and the evidence, limited by the law. And they shouldn't be influenced by political actors, by political parties, by political administrations. That's not justice. That's not how democracy is supposed to work and operate in the United States of America.
U.S. attorneys are political appointments. But do you think that Trump's picks are even more charged politically? I mean, he just withdrew the controversial nomination of Ed Martin to be the D.C. U.S. attorney.
Well, I think the problem is that we know that this particular president values loyalty perhaps above all things. Loyalty. And so whatever he wants done, he expects the persons that he has placed in those positions to do what he wants them to do with no questions asked. And when I was a prosecutor, I never, ever was looking over my shoulder thinking, I better not decide this matter this way or take this particular action because of political concerns or political retaliation or I'm going to be demoted if I do this or I do that. That never entered my mind. The political implications, whether this would favor a political party or disfavor a political party, was never a consideration ever. And now it appears to be a consideration always. There's this kind of black cloud, I think, over federal prosecutors as to, is there going to be retaliation? And that's very chilling. That's very chilling. It's very disturbing. And it's not what one would expect to happen in a free, open democracy. That's what you would expect and what we often see in countries that are run by authoritarian governments and authoritarian presidents.
Can you think of any case even similar to what the U.S. attorney is doing here or trying to do here?
I can't stress enough just how shocking, how unprecedented it is. I mean, I've been at this. I was a prosecutor for 9 years before I joined the law faculty here. I've been here for decades now. I cannot recall a federal case where this has happened, where the prosecutor said, oops, we initiated this prosecution. We initiated the criminal charges. We advocated to the jury for conviction, and now we want that jury conviction to be vacated. Not for anything that was done wrong at the trial or because of insufficient evidence or newly discovered evidence that proves his innocence. No, just because now the new sheriff in town doesn't like the result.
And there's also the possibility of a presidential pardon. Thanks so much, Jimmy. That's Professor Jimmy Gurule of Notre Dame Law School.
We have a public health crisis in this country.
But the day before talking about our nation's public health crisis, Health Secretary Robert F. Kennedy Jr. had announced a massive restructuring of the Department of Health and Human Services. It included cutting more than 20,000 employees, nearly a quarter of its workforce, reducing regional offices from 10 down to 5, and collapsing 28 divisions into 15. The cuts were made as part of a directive the Trump administration has dubbed Make America Healthy Again. But Democratic attorneys general from 19 states and D.C. say the sweeping restructuring is doing just the opposite, destroying life-saving programs and leaving states to pick up the bill for mounting health costs. New York Attorney General Letitia James is leading their federal lawsuit filed on Monday, asking a court to stop the dismantling and mass firings and to restore the programs that have been cut.
These actions are dangerous, cruel, and illegal. They defy Congress's authority, and they violate federal law. And that is why today I am leading a lawsuit joined by Democratic attorneys general across the country to stop this administration from tearing down our public health infrastructure.
Joining me is healthcare attorney Harry Nelson, a partner at Leech Tishman Nelson Hardiman. Harry, in general, how has RFK Jr. changed the department?
There's been a pretty significant amount of changes. I think the biggest change has been employee layoffs affecting nearly every major sub-agency within the Department of Health and Human Services, including the Center for Disease Control, the FDA, the National Institute of Health, and others. There's just a lot fewer personnel in place. As you mentioned, there's been a consolidation of 28 total sub-agencies within Health and Human Services down to 15 with various mergers and eliminations. A number of closures of public health programs. The FDA passed on a bird flu vaccine application due to some of the lab shutdowns. The Center for Disease Control halted measles testing despite a nationwide outbreak that we've been seeing. NIH has been suspending research trials. Those have been the major disruptions. There's been a few smaller ones. There was a specific post-9/11 program for first responders that has been interrupted because of staff shutdowns. And, of course, DOGE, the Department of Government Efficiency, is continuing streamlining organizationally, getting rid of people, and, every day is bringing new changes.
And tell us about the allegations in the lawsuit.
Sure. So they filed suit in Rhode Island, and they've essentially alleged that all of the actions we just described are illegal, and they undermine the Department of Health and Human Services' ability to fulfill its statutory obligations. So specifically, they allege a violation of the Administrative Procedure Act, which are the rules by which government program changes happen, so that there's notice and an opportunity to be heard before rules are made and before there's any changes. There's an allegation in the case of a violation of the separation of powers, that the executive branch has essentially stepped in and dismantled programs that were authorized specifically by Congress, invading Congress's authority. And there's an allegation that many of the specific laws related to public health are being violated, like the first responders example, where there's people out there, stakeholders, who are beneficiaries of these programs whose rights are being violated. So those are the primary legal theories in this case.
Do they take aim at Kennedy's larger public health agenda and, his opposition to vaccines and fluoride in the water?
That is really not part of this case. I mean, this case is much more about the downsizing, the radical downsizing of this agency and the way that it proceeded, and not about RFK's specific idiosyncratic views. And frankly, it's not clear to what extent his views are driving this, because the behavior in many ways parallels what we see that same agency, DOGE, doing in other parts of the federal government. So it in many ways looks like a broader ideological disruption and downsizing of a federal agency rather than like RFK's disbelief in particular kinds of health programs.
So it's following the pattern of other lawsuits that claim the executive branch can't incapacitate an agency like HHS without Congress signing off, and that the administration is violating the appropriations clause because Congress already authorized funds for the agency's operations.
Yeah, it really is the greatest test of constitutional powers and what the executive can do to essentially shut down all these programs that Congress authorized and established. It's a fascinating moment in terms of constitutional principles and how far executive power can go.
Last week, the Trump administration released a proposed budget, which has a 26% cut to the HHS discretionary budget, but asked for $500 million for Kennedy's Make America Healthy Again initiative. Let's say the proposed budget is approved by Congress. Does this suit then lose some of its power because Congress has decided to cut the budget for HHS?
I think this case is much more about the process, again, about the administrative process by which things have proceeded than about the actual funding changes. The funding changes that are proposed are certainly directionally the same as some of these changes, but right now we're in an already funded environment where monies have already been allocated and we're not talking about it. So the two things do go kind of hand in glove, but it's a slightly different issue because the money is authorized. Congress has made choices by virtue of our previous budgets. And so if the 2026 budget, is enacted, frankly, it will be different cuts on the same trajectory, and it'll have additional further impacts, but these are two different things.
So there's also similar cases that try to block the termination of billions of dollars in grants awarded by federal health agencies in support of public health research. I keep hearing about cuts in funding to research. Is this like overblown, or is it really a serious threat to research?
No, this is affecting our medical and public health research institutions across the board nationally. I believe in the 2026 budget, the proposal is $18 billion less funding for biomedical research being conducted. We're talking a massive scale of reduction, assuming that it's going to be consistent with what RFK's indicated. We can expect the cuts to come from new drugs and more specialized health conditions because RFK's, been promising that there's going to be a greater focus on chronic conditions where there is, in theory, more bang for the buck in terms of the number of people affected and a focus on, more disease prevention of things like diabetes. So I do think that this is a profound shift for the pharmaceutical industry, for all of the universities and all of the academic researchers at our health systems around the country, like radical changes in labs being shut down, projects being shuttered, and just a massive, massive disruption.
Thinking about the USAID, which was the first agency to be dismantled, basically, by DOJ. And in those cases, even though the judges said that, you can't dismantle an agency completely, it was already too late by the time the judge's orders came out. I mean, people had been fired already, and things had already started to disintegrate. So might the same thing happen here? I mean, he's already done the damage.
It's a fair question. I mean, a lot of the researchers are people who have jobs, for example, many people who are they might be researching cancer and also treating in a local hospital. So in the case of a lot of our research institutions, you have different categories of researchers in different places who are going to be affected differently. Obviously, people who are literally within the National Institute of Health, if their positions are cut, are going to have to look for new jobs. But what I'm hearing is a lot of uncertainty for doctors who were including research activities, in their priorities. I think the cuts represent something like 1/3 of the total budget of the National Institute of Health. And again, it's going to be interesting to see where it hits. The single biggest category, of course, in the United States is cancer research. We have enormous research dollars going into mental health, infectious disease, and it's not clear that any of those areas are going to be priorities. We have billions of dollars going into HIV/AIDS research, various rare diseases, aging. It's not clear where any of it's going to go, and it can't be good for the advancement of public health. And in many ways, it does look like the dismantling of something that has been sort of a real jewel in the American public health system.
Obviously, they haven't filed a response yet. I mean, what might their possible defense be?
I mean, it's really a question of how far executive authority goes. The Department of Health and Human Services is part of the executive branch. So in theory, the administration has the power, even though Congress authorizes the funding and allocates it, the administration gets to decide how the agency is working. And I think what we're going to hear from this administration is that this agency was bloated, that it was too big, too inefficient, that there was no accountability, and that they are essentially taking a painful step that reduces red tape and kind of forces federal health policy to be improved by forcing more action into the states and in the communities rather than with the centralized federal mandates. So those are the arguments they're going to make. They're going to argue about waste and about budget deficits, but it'll be interesting to see how the courts treat this one, and it would not surprise me if this ends up in the Supreme Court.
RFK Jr. was a very controversial pick for HHS secretary. And during his confirmation hearings, because he is a vaccine skeptic, to put it mildly, he made promises about not disturbing vaccines. But has he already started to undermine vaccines in different ways?
Absolutely. There's definitely been, I would say, a quiet rollback on numerous vaccines. And we're already seeing essentially vaccine opportunities foregone, like with the bird flu, based on lack of personnel. And I do think it's happening sort of in a lot of quiet steps rather than in one fell swoop. I expect that will continue based on not only RFK, but the people around him for whom this is really a kind of passionate point. RFK has enormous power as the head of the agency. And what we're seeing is a number of key public health positions are going to people who are really passionate ideologues for all of the positions that he's espoused. And so we're seeing a number of anti-vax people in leadership roles. And obviously that doesn't bode well for getting us ready for the vaccines we're going to need in the coming years.
And the AG's lawsuit paints a frightening picture.
It's radical, and it feels like deliberate sabotage of our public health infrastructure and an illegal power grab without any plan of how this impacts anybody. Our health research has been, without question, the strongest in the world, and it's hard to believe that if we have 4 years of continued cutting, that it will bear any semblance of what it was.
We'll see if the judge issues an injunction. Thanks so much, Harry. That's healthcare attorney Harry Nelson. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcasts. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.